So another important Second Amendment case is up for review, and this one involves the possession of firearms by nonviolent prohibited people. So let's talk about this. But real quick, I want to thank the sponsor of this video, which is Ground News. In today's world, many of us are very frustrated by how the mainstream media is currently covering news and how they cover it with a very clear political or societal bias. Ground News is a website and app that helps you uncover the media bias that maybe is behind the news story that you're currently reading. Ground News is a platform that makes it easy to compare news sources, read between the lines of media bias, and break free from the current algorithm that maybe you've been placed in. Ground News is a platform that makes it easy for me to be able to search between headlines to discover which details are maybe being emphasized, exaggerated, or maybe even being left out entirely. The most useful feature to me is the comparison tool, which swipes between headlines to see how maybe the same story is being framed by the left, center, and by the right. So if you're looking for a better way to stay informed, go check out Ground News. I left a link to them down below. And thank you again, Ground News, for sponsoring this video. As I mentioned in the intro, in this video, we will be discussing an important Second Amendment challenge that is now currently up for review before the Third Circuit en banc panel. The case we're going to be talking about in this video is called Range v. Garland, and it involves a challenge to federal laws which prohibit someone with a nonviolent felony from being able to own or possess firearms, essentially them being stripped of their right to keep and bear arms. This is one of those really important Second Amendment issues because there are countless individuals in the US who have been stripped of their right to keep and bear arms because of minor conduct and even after they've even served their time. And now in February, the full en banc panel in the Third Circuit Court of Appeals will be considering this very issue. Now the facts surrounding this case are as follows. 26 years ago, an individual named Brian Range was convicted of concealing some of his income so that he could obtain some food stamps for his family. Essentially, he simply was making false statements on a form. Now in the state of Pennsylvania, that is a Class 1 misdemeanor, and he was convicted of that misdemeanor. Now, Mr. Range served no jail time. He eventually pays his restitution. He's currently employed. He's a peaceful individual. He's a productive family man. He has no other criminal record that's been disclosed. And essentially, he was convicted of only that one incident because he hid some of his income on a form when he was filing for some food stamps. However, because of that one incident and that misdemeanor conviction, the government therefore bans Mr. Range forever from being able to possess firearms. Mr. Range is barred from possessing firearms per 18 U.S.C. section 922 G1 on account that he has a misdemeanor offense which posed no danger to anyone else, did not involve any force or threat of force, and resulted in absolutely no jail time. On that basis of him being a prohibited person and no longer being able to possess any firearms, he filed a lawsuit against the federal government. He filed a lawsuit against the Attorney General and the ATF as well. Mr. Range brought his lawsuit originally before a district court in the state of Pennsylvania against the ATF and the Attorney General, seeking declaratory and injunctive relief. He sought for the federal government to no longer be able to bar him from possessing firearms only because of that one nonviolent misdemeanor 26 years ago. However, on review, the district court judge ruled in favor of the government on a motion for summary judgment. In doing so, the court used a two-step approach. The district court declared that it would first consider whether Mr. Range's conduct is sufficiently serious for Mr. Range to lose the Second Amendment rights, and then, should it find that the Second Amendment is not implicated, it would consider whether the government has carried its heightened scrutiny burden. If that type of framework sounds familiar to you, that's because it's similar to the other types of two-step approach, which the Supreme Court recently struck down in New York State Rifle and Pistol Association v. Bruin. In Bruin, Justice Thomas, writing for the majority, stated, "Today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulations. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." However, on review, the district court in this case found his nonviolent misdemeanor would qualify for him to lose his right to keep and bear arms. Now, after losing at the district court level, Mr. Range appealed that decision up to the Third Circuit. On review, a 3-judge panel at the Third Circuit level issued an opinion upholding the lower court's decision, and they cited Bruin in doing that. However, on review, the district court found his nonviolent misdemeanor would qualify for him to lose his right to keep and bear arms. Now, after losing at the district court level, Mr. Range appealed that decision up to the Third Circuit. On review, a 3-judge panel at the Third Circuit level issued an opinion upholding the lower court's decision, and they cited Bruin in making that ruling. The 3-judge panel cited history and tradition in finding that the individuals constitutionally entitled to bear and keep arms are only law-abiding, responsible citizens. That category, the panel held, properly excludes those who have demonstrated disregard for the rule of law through the commission of felony and felony equivalent offenses, whether or not those crimes are violent. So here the Third Circuit found that his misdemeanor, although non-violent, was equivalent to a felony, and therefore he was excluded from the class of people which are afforded the right to keep and bear arms under the Second Amendment. Well, we recently received the following order from the Third Circuit en banc panel, and the order states that they will in fact grant review of this case. It states, a majority of the active judges having voted for a rehearing en banc in the above captioned case, it is ordered that the petition for rehearing is granted. The case will be argued before the en banc court on Wednesday, February 15th at 10 a.m. The opinion and judgment entered November 16th, 2022 are hereby vacated. So the Third Circuit en banc panel is rehearing this case. That is interesting considering the 2 lower courts here have found in favor of the government, in favor of the Attorney General, the ATF, which indicates there is enough interest at the Third Circuit level to likely overrule those lower court decisions. No doubt, despite what happens here before the Third Circuit en banc panel, there will likely be some sort of a petition filed up to the Supreme Court. There will likely be a writ of certiorari. This issue of nonviolent prohibited people being in possession of firearms has been a topic many have wanted the Supreme Court to ultimately rule on. In fact, you had one of the justices, Justice Amy Coney Barrett, at the 7th Circuit level when she was on the 7th Circuit, she actually wrote a dissent in a similar case called the Cantor case. That case also dealt with a nonviolent felony possession. That case, I believe, dealt with mail fraud, where a man was selling some sort of counterfeit insoles over the mail or something like that, and as a result, he committed a nonviolent felony and then lost his right to keep and bear arms. In Cantor, Justice Barrett found and wrote a dissent, essentially finding that the types of individuals that are excluded from the text of the Second Amendment should not be these nonviolent individuals. Really, the Second Amendment maybe would exclude violent individuals, but these types of individuals with these petty crimes were never meant to be excluded from the Second Amendment. Now, if you were to ask me, these petty nonviolent crimes were nowhere near the types of incidents that our founders envisioned would actually exclude people from their right to keep and bear arms. In my opinion, if it is a nonviolent issue, if it's a nonviolent misdemeanor or nonviolent felony, some of these petty crimes, you pay your fines, you pay your time, whatever, and you're a free person, you should not be stripped of your right to keep and bear arms. But that's just my opinion. However, this is a really important case and is likely going to be really important for a lot of people who maybe have been stripped of their right to keep and bear arms because of some of these really petty convictions that they may have. So I will be keeping my eyes on this case. I will likely be listening to the oral arguments on February on that date. If you guys are interested maybe in a live stream, maybe we can do something like that. If you're interested, leave a comment down below in the comment section, and maybe if there's enough interest, we can do something like that. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.